Friends, in the earlier part, we have discussed the background under which the IBC has been enacted, IBC has been passed by the government, and there's what is a coverage. Who are the parties? Which type of parties are means entities are covered under the IBC? Then we have also seen what are the actually the objectives and the objectives or purpose of set means establishing this IBC. And the latest one we have discussed about the pillars of IBC. And when we discussing the pillars of IBC, we discussed there are four pillars. Like in a building, there are four pillars. Here, the first one is insolvency professional IP. Second one is information utilities, and the third one, as I told you, that adjudicating authorities, and the fourth one, that's insolvency bankruptcy board of India, IBBI. And in the third part, in the adjudication process, we have discussed that corporates and LLPs can be referred to NCLT, National Company Law Tribunal, for their cases for insolvency and bankruptcy. So here NCLT, suppose the NCLT passes an order, then that aggrieved party can make an appeal before the next tribunal, that is known as the National Company Law Appellate Tribunal, NCLAT. That appeal can be made within 30 days of the date of the order passed by NCLT, and in exceptional cases further extension or 15 days can be given. And NCLT, any order passed by the NCLT, the aggrieved party can again, there is one more resort, that is they can refer to Supreme Court, provided it is a matter, provided the matter is of law. No other issues can be entertained by Supreme Court. If it is a law, it can be, that too within 45 days of the order passed by NCLAT, the appeal can be made to the Supreme Court in case of any law, a law relating to the law. That is about corporate and LLP. Now, so far as partnership and individuals, the adjudicating authority is DRT, and DRT they got appellate. This one is DRAT, Debt Recovery Appellate Tribunal. And any order passed by the DRT, the aggrieved persons can make an appeal if need be before the DRAT within 30 days, and in exceptional cases 15 days more, so maximum 45 days. In the normal case only 30 days. And if the order passed by DRAT is also not satisfied by the aggrieved party, then he can make an appeal before Supreme Court only in respect of the matter relating to the law. That too within 45 days of the order passed by the DRAT. That is in a nutshell about these appellate adjudicating authorities. Now the fourth pillar is, that is Insolvency Bankruptcy Board of India. That's IBBI, we can call it as. IBBI is a regulatory authority so far as the code is concerned. Regulatory authority, and it creates an institutional framework. And here all the other three agencies are coming under, the other two agencies, that is insolvency professional and information utilities, are coming under this one. And arbitration, there is adjudicating authorities are different. So these all the things are coming under the, means all other three pillars including adjudicating authorities are coming under the IBBI. IBBI, as I told you, it is a regulatory authority, and this to facilitate the formal and time-bound insolvency resolution process and liquidation. This is their main objective of the setting up of the IBBI, is to facilitate a formal and a time-bound program, time-bound insolvency and bankruptcy process and its liquidation. That is IBBI's role. Then what are the provisions available under the code, under the IBC? There is one is the time frame. As I told you, the resolution should be addressed. Resolution should be completed and implemented so far as viable unit is concerned within 180 days of the application. Within 180 days, it should be completed and implemented. And in exceptional cases, further time of 90 days can be considered. So maximum, as I told you, 270 days. That resolution should be completed, implemented within 270 days in very, very exceptional cases. Another feature of this IBC is that the creditors have that assess the viability of the debtor. That is one of the important features available in this system. Assess the viability of the debtor as a business decision and agree upon a plan for revival or a speedy resolution. So viability can be established by the creditor concerned. That's the lenders, and they can take a decision. They can take the call whether to go in for a resolution, go in for a revival resolution, or a liquidation process, or a speedy liquidation. That provision is there. Now, what is the process involved in this, either this resolution process or the liquidation process? The process that is as I told you, there are two processes involved. One is insolvency resolution process, that is so far as viable units are concerned. Viability, that unit would be in a position to service the interest and the principal within a specified time frame, start repayment within the specified time frame. So such units are viable. They can generate adequate income so as to take care, so as to service the interest and installments wherever feasible. Then it can be, then second one is, if the failure of this resolution, then you have to consider the code provides for liquidation. That is, in solvency, there is a resolution of the insolvency resolution process, that is one. Second one is liquidation process. The insolvency resolution, we can say that corporate insolvency resolution, so far as a corporate, that is most popular. Corporate insolvency resolution process, we can call it as CIRP, corporate insolvency resolution process. It can be initiated by either a financial creditor or a operational creditor or the principal debtor itself. What is or the corporate debtor itself? Debtor can also go to these NCLT so far as corporate is concerned. It's a corporate, then they can. What is financial creditor? That is a creditor in terms of the financial, in terms of money. When the finance is provided, so far as lenders are concerned, they have provided the finance. So they are the financial creditors. Whereas the operational creditor is where the creditor has provided goods and services. Thereby the dues are to be, the dues are there. So that operational creditor, goods and services. Third one is the debtor itself, corporate debtor itself. So the stages, what are the process? That is, these are the three parties can approach the NCLT so far as a corporate is concerned, that financial creditor, so far as the financial matters are involved and the dues are pending. That is credit, just like the banks, lenders, financial institutions, etc. And then operational creditor, that is for the service, that is goods and services rendered to the payment thereof. That is operational creditor and the corporate debtor himself. Okay, corporate debtor himself. Okay, and what is the process? First one is an application to NCLT by the lender, the financial creditor. Financial creditor can make an application before the NCLT for either liquidation or insolvency resolution. Suppose operational creditor, though, then there is one of the preconditions for them. First, they will have to issue a notice giving 10 days. We can say that 10 days demand notice, asking them to pay the money within the time frame. If the party, the debtor, fails to make the payment, then only the operational creditor can approach NCLT for a redressal. or for any either resolution or for liquidation. Then first step would be once the application is made, then what is that IBBA? The NCLT will first they will appoint an interim insolvency professional. Insolvency professional will be appointed within 14 days of the receipt of the application. Then IP will give a public notice regarding initiation of the corporate insolvency process, initiation of the CIRP, corporate insolvency resolution process. Then a public notice would be made, and they will call for any claim from the other creditors also, if at all it is there. And then this is second stage. Then comes the first creditors meeting. All creditors will be assembled. They would have a first meeting within 7 days, and they will have to decide then whether to replace or to continue with or confirm the IP. There it is the majority voting. That is, the creditors will have the voting majority, 75% voting. Percentage of votes are in favor of the IP. Then IP will be continued as a continued there. If the creditors of an otherwise view, any other view, in that case the IP will be removed and someone else would be placed in place of this IP. The IP will be reappointed or confirmed or replaced. Okay, this is what third stage. That too 75% of the votes of the creditors. Then afterwards the IP, then this will be appointment of the resolution professional. That is, IP himself can be acting as a resolution professional by NCLT. NCLT will do it. Who will take care of all further proceedings? Resolution professional by NCLT. Then there the creditors committee will be deciding the decision on the insolvency by the creditors committee. It was earlier, as per the act, it is 75%. Now recently an amendment has taken place couple of days before. I mean, not couple of days, in a week or so before, as per the amendment, that is 66% of the vote. The resolution, if at all the unit is viable, with the 66% creditors vote, this resolution plan can be taken ahead. Then, if the creditors committee decides that due to certain unknowable reasons, further extension of time is required, they can approach NCLT, and further time up to 90 days can also be granted, making total completion within 270 days, 180 plus 90. Then conducting the resolution by RP. RP will do all the resolution process. Then committee decision on the restructuring upon passing a resolution committee. Resolution committee will take a resolution. There is a creditors committee will pass a resolution for any restructuring is to be carried out. When that unit is viable, then restructuring will go. Then restructuring or refacement, or as the case may be. But that is based on the creditors decision, creditors committee decision. If that is done, then if no decision is taken within the time frame, then it will be referred for liquidation. The liquidation in case decision by the committee. Suppose it is not viable, the liquidation or committee's decision. If the decision is not taken within 180 days, then also it will be automatically shifted to liquidation proceedings. Then implementation once approved by NCLT. Then sending this resolution plan to final approval to the NCLT. Resolution plan, if it is a viable unit, resolution plan is to be approved by NCLT, and if it is for liquidation also, finally it will be sent to NCLT. NCLT will give approval either to go ahead with this resolution plan or to go in for liquidation of the company, the corporate. This is what the procedure. What are the process involved in liquidation? That this is about the resolution plan for the revival. Then liquidation. The secured creditor has a right either to dispose of these assets, either to dispose of the assets and get the share of their share from the proceeds, or enforcing security interest towards the recovery of the dues, enforcing or relinquishing their rights. Your right, the right can be relinquished in favor of the liquidation trust. One trust would be formed. They will take entire assets and they will dispose it and they will get the proportionate share. So they relinquish their right over the assets in favor of the liquidation trust, and relinquishing the right in liquidation trust and contingency for shortfall, if any. That is, any contingency shortfall comes, that is junior to, means after unsecured creditors are met, then only contingency anything comes. Any shortfall comes, that will be met, not from the principal other realization. Okay. Now, when this liquidation proceeding can be commenced, first one, failure to submit the resolution plan to the NCLT within the time frame. That is one, within 180 days. One, the rejection of the resolution plan by the credit committee. That is also the rejection. Then decision of the credit committee is based on the vote of majority. That is 66%. There it will come. Rejection or of the resolution plan for non-compliance with the requirement of the code. Is not fitting within the guidelines, within the ambit of the or framework of the code. In that case, this can be declined. Then if it is by the majority, 66%, okay, this can be taken up for liquidation. Then contravention of the resolution plan by the debtor. If the resolution plan itself is contravening the all other norms, then it can be taken up for liquidation. No consideration of resolution process. Okay. Then during this period, even for the resolution plan, all the suits or any action, coercive action, everything gets stalled. So free. They cannot. No court can enforce anything. It is everything is no suit, no other proceedings shall be initiated and everything will get stalled. That is this one. Either it is 180 days or 270 days. Then the resolution process shall act as a liquidator unless replaced. If the RP is continuing, then he can be acted as the liquidator for liquidation trust and everything. And liquidator also, they can dispose it of and appropriate the proceeds among the creditors. Liquidator shall form asset of all assets. That is liquidator state. Liquidator will form. Then liquidator will, liquidator's duty is to process all the claims or process the claims, appeal to the adjudicator. Then any claimant is not satisfied with the process or share, he can make an appeal before the NCLT, the adjudicator, that is NCLT, or a DRT in the case of individual and partnership within 14 days of the rejection. Realization either realization either by direct selling or by this liquidation or a trust, liquidation trust it can be. Upon liquidation, the liquidator making on application, the NCLT will pass an order for a dissolution of the corporate debtor or corporate entity. Once the liquidation process is over, then it will be referred to NCLT. NCLT will pass an order for dissolution of the corporate debtor. That is, we have seen that resolution process. So we have second stage, that is liquidation process. When it can take the liquidation process and what is the procedure. Now comes, as I told you, fast track insolvency process. That government notifies the qualification. That is time frame in the as against the earlier one. Normal course is 180 days. Here it is 90 days. And in exceptional cases, further 45 days can be considered. So in all total 135. But it is very exceptional cases. Or else normally it can be considered only for 90 days. Applicability, that is normally it is applicable for startups and SMEs. So for us, it's a fast track method. Purpose, fast completion of the resolution. That is why the fast track. We consider fast track insolvency proceedings. Okay. Then voluntary. That is, suppose a corporate can go ahead. Corporate can go ahead and self. Voluntarily, they can make a commitment. Yes, let this business be liquidated. That is, they will have to pass a resolution, and that intention should be intimated to the NCLT. Intention to liquidate, and then because there should not be any commitment. There should not be any default. If anybody goes for this one liquidation unit, there is no default. Default, then that is not they are not eligible for considering this voluntary liquidation. Not committed any default and adequate full liquidation of debts. Whatever debts are there, that will be taken care from the assets available. Then the creditors will also agree to that. Declaration from the creditors will also agree to that. Then declaration from directors also will declare, yes, we are in agreement with the liquidation of the particular business entity. If any creditors are there, they will also agree. Then the resolution duly agreed, approved by, that resolution would be passed, and the creditors will have to approve 2/3, that is also 66%. 2/3 this one to be passed by the creditors committee or creditors. Then NCLT will pass for the voluntary liquidation or voluntary dissolution. This is actually this is the procedure for, we have seen the procedure for the corporate. Corporate, the same for individual as well as the partnership. Also the procedure is same. Here instead of NCLT, those cases of partnership and this one partnership and individuals, that application is to be made before DRT. Procedure is the same. Liquidation proceeding is also same. Now coming to this one, as I told you, there is an order of priority. So here, order of the priority, these lenders are concerned, they are the secured creditors. The order of priority, as the Act provides, the order of priority, whatever the amount going to be realized, either by the liquidator or by the liquidation trust or by the director, this one, that should be apportioned as per the order of priority. The first priority should be the workman's dues, that is due for 24 months, not beyond that. 24 months before commencement. Before commencement of the resolution liquidation proceeding, 24 prior to that, 24 months dues, that can be given the first priority along with the secured creditors. So the lender is also getting the first priority, but along with the workman's dues for 24 months prior to the commencement of the liquidation proceedings. That is one. Second one, this wages and unpaid salaries, wages and unpaid dues to employees other than workmen. Workmen, the first one, 24 months. Other than workmen, other wages and we can say the unpaid salaries, etc. Other than workmen for 12 months prior to commencement of the liquidation proceedings. So that 12 months will be the second priority. The order, first one is workmen 24 months plus secured creditors, both equal in the first category. Then come next wages and unpaid dues employees other than workmen for 12 months before commencement. Then financial debts to unsecured creditors. So for a lender is concerned, that is secured, and unsecured creditors and workmen's dues for earlier period. Workmen's dues beyond 12 months, 24 months, that will be taken along with the unsecured creditors. Crown debts and debts to secured creditor following enforcement of security interest. Any residual, any shortfall, everything will be taken after unsecured creditors. That is, I said, they will get a priority after the unsecured creditors. Unsecured creditors, financial debts to unsecured creditors and workmen dues earlier period. Afterwards only the residual, means shortfall, would be taken care as per the Act. Then any remaining debts. Then preference shareholders, did you say anything is there? Preference shareholders, shareholding, they can be returned provided sufficient realization is there. Then comes last equity shareholding of the shareholder or partners, equity shareholding or partners. So we have discussed, friends, IBC, the background, IBC coverage, IBC, then how it can be processed, and this resolution process, and what is the objectives of this one, and resolution process, and the liquidation process, voluntary liquidation, then fast track liquidation, and also we have seen that order of priority. Now I think you must have got this uh, idea about this in insolvency and bankruptcy code. Okay, so I take this opportunity to thank you everyone. This most of the points have already been covered here.